The federal courthouse at 300 Pearl Street that has hosted some of the most consequential legal proceedings in American history for over a century just erupted into chaos that left seasoned court officers stunned. Not because of a security threat, not because of a technical malfunction. Judge Aileen Cannon said it herself on the record. Testimony had to be halted due to procedural violations so severe they threatened the integrity of the entire proceeding. I'm Elizabeth Carter, and this is Independent Judicial Watch. Before we go any further, I need you to do something right now. Hit that subscribe button, click the notification bell. Leave a comment below telling me if you've ever witnessed a courtroom proceeding go off the rails. Share this video with everyone you know. This is the only official channel documenting judicial accountability in real time. What I'm about to show you happened yesterday afternoon in downtown Manhattan, and the legal precedent being shattered affects every American. Here's the core argument tonight in plain language. When established courtroom protocol breaks down so completely that a federal judge must physically remove participants and halt sworn testimony, we are witnessing the collapse of legal accountability itself. This isn't about politics, it's about the rule of law. Tonight, I'm going to walk you through the court documents, witness statements, and legal expert analysis so you can see exactly how we got here and who's going to pay the price when our justice system loses all credibility. For months, this particular courtroom has operated under standard federal procedures that have governed American legal proceedings since 1938. The federal rules of civil procedure exist for one reason: to ensure fair trials where evidence can be presented, witnesses can testify, and justice can be served. These aren't suggestions. They are the foundation of our entire legal system. What happened at 2:47 p.m. yesterday afternoon shattered that foundation. According to court transcripts obtained through Freedom of Information Act requests, the proceeding was moving through routine direct examination when defense counsel began what court reporter Margaret Henderson described as unprecedented disruption of witness testimony. Henderson, who has been documenting federal proceedings for 30 years, told reporters, "This was unlike anything I've seen in 3 decades of court reporting." The witness was attempting to answer questions under oath when the entire process simply collapsed. Translation: the basic function of our court system, allowing sworn witnesses to tell the truth, was actively prevented from happening. Judge Cannon's order to halt testimony came after what legal scholars are calling a systematic violation of courtroom decorum that made it impossible for the judicial process to continue. The official court filing states, "Due to persistent disruption of sworn testimony and willful disregard for judicial authority, this court has no choice but to suspend proceedings and remove disruptive parties from the courtroom." Think about that. A federal judge had to stop a witness from testifying under oath because the courtroom itself had become dysfunctional. Dr. Sarah Martinez, constitutional law professor at Georgetown University, explained the significance. When a federal court cannot maintain basic order sufficient to allow witness testimony, we have crossed a line that threatens the entire judicial branch. This isn't about one case or one judge. This is about whether our courts can function at all. The ripple effects are already spreading. Within hours of yesterday's incident, 3 similar disruptions were reported in federal courts in Virginia, Georgia, and Texas. Legal experts are warning that we may be witnessing the emergence of a coordinated strategy to render the federal court system unable to conduct basic judicial functions. And here's what nobody is saying out loud. If courts cannot hear testimony, they cannot render verdicts. If they cannot render verdicts, there is no legal accountability for anyone. And then it got worse. What happened in that courtroom violates legal precedent that has stood unbroken since the establishment of federal courts in 1789. In 237 years of American jurisprudence, federal judges have maintained the authority to conduct orderly proceedings where witnesses can provide sworn testimony without interference. Yesterday, that foundational principle crumbled. Professor James Richardson, former federal prosecutor and current director of the Judicial Accountability Project at Harvard Law School, reviewed the court transcripts and told me, "What we witnessed represents the first successful disruption of federal judicial authority in modern American history. The implications extend far beyond this single case. When courtroom proceedings cannot continue due to deliberate interference, the entire concept of legal accountability becomes meaningless." Translation: our justice system depends on the ability to hear evidence and testimony. When that becomes impossible, there is no justice system. Here's what the legal experts are not saying publicly, but are discussing in private. This incident establishes a dangerous new precedent. If courtroom disruption can successfully prevent witness testimony, then any defendant with sufficient resources or organization can render themselves immune from legal consequences simply by making trials impossible to conduct. Dr. Lisa Chen, constitutional scholar at Yale Law School, explained the domino effect in stark terms. First domino, courtroom procedures are disrupted through calculated interference. Second domino, judges lose the ability to maintain order necessary for legal proceedings. Third domino, the entire federal court system becomes unable to fulfill its constitutional mandate to provide equal justice under law. Let that sink in. The federal rules of evidence, established in 1975, create a framework that has allowed American courts to function for nearly 50 years. Rule 611 specifically grants judges the authority to control the mode and order of examining witnesses and presenting evidence so as to make those procedures effective for determining the truth. When that authority is successfully challenged, as happened yesterday, the entire legal framework begins to collapse. Margaret Henderson, the court reporter with 30 years of experience, provided additional details that reveal the calculated nature of what occurred. She told reporters, this wasn't spontaneous disruption. There was a deliberate pattern of interference designed specifically to prevent the witness from completing testimony. I've documented everything from emotional outbursts to technical difficulties, but I've never seen systematic obstruction that made it impossible for sworn testimony to proceed. Think about that. A veteran court professional is telling us this was not chaos. This was strategy. Federal Judge William Thompson, who has presided over high-profile cases for 20 years, reviewed the incident and provided context that should alarm every American. When courtroom disruption becomes an effective legal strategy, we are witnessing the weaponization of procedural chaos against the rule of law itself. This represents a fundamental attack on the judicial branch of government. And here's where the legal precedent becomes undeniable. In United States versus Illinois, the Supreme Court established that the ability to conduct orderly legal proceedings is essential to the constitutional guarantee of due process. When proceedings cannot continue due to deliberate interference, due process is denied not just to defendants, but to the American people who depend on functional courts for legal resolution. The legal community is scrambling to respond. The American Bar Association issued an emergency statement calling for immediate review of courtroom security protocols. The Federal Judges Association has requested urgent consultation with the Administrative Office of the Courts. Legal scholars are drafting emergency briefs arguing that systematic courtroom disruption represents contempt of court on a scale that threatens judicial independence itself. But here's what nobody is saying out loud. If this strategy spreads, if courtroom disruption becomes the standard response to unwanted legal proceedings, then every American loses access to functional courts. Civil disputes cannot be resolved, criminal cases cannot be prosecuted. The entire system of legal accountability disappears. And that is exactly what appears to be happening across multiple federal districts right now. Now let me show you who was really in that courtroom and why they wanted testimony stopped. Judge Aileen Cannon represents what I call the silent authority. Appointed to the federal bench in 2020, she has presided over high-profile cases for 4 years without a single incident of courtroom disruption requiring testimony to be halted. Yesterday, she found herself in the impossible position of choosing between allowing systematic interference to continue or taking the unprecedented step of removing participants and suspending proceedings. Her official statement reveals the calculation behind her decision. After exhausting all standard judicial remedies for maintaining courtroom order, this court determined that continued disruption posed a direct threat to the constitutional right of witnesses to provide truthful testimony under oath. Translation: she tried everything else first, and nothing worked. The defense legal teams involved represent what I call the corporate messengers. These are not public defenders working with limited resources. These are elite law firms charging premium rates to execute strategies that have nothing to do with legal defense and everything to do with systematic disruption. Wilson, Sonsini, Goodrich, and Rosati, billing at over $2,000 per hour, coordinated what court observers described as a deliberate campaign to make witness testimony impossible. Senior partner Michael Harrison told reporters outside the courthouse, "Our clients deserve vigorous representation within the bounds of established legal procedure." Translation: we got paid millions to prevent testimony and we succeeded. Dr. Elena Rodriguez, professor of judicial ethics at Columbia Law School, represents what I call the warning expert. She has been documenting the erosion of courtroom civility for the past decade and predicted exactly this scenario in a 2023 Law Review article titled When Legal Strategy Becomes Legal Sabotage. She told me, what we witnessed yesterday is the logical endpoint of treating courtroom proceedings as political theater rather than legal process. When high-priced legal teams are rewarded for preventing testimony rather than presenting defense, the entire adversarial system collapses. Think about that. Legal experts saw this coming and warned us. And here's the irony. The federal rules of civil procedure were designed to ensure fair trials by establishing clear guidelines for witness examination, evidence presentation, and courtroom conduct. Those same rules intended to protect the integrity of legal proceedings were weaponized to destroy the very process they were meant to preserve. Let me show you the numbers. In the past 6 months, federal courts have documented 47 incidents of significant courtroom disruption during witness testimony. That represents a 340% increase compared to the same period last year. The cost to taxpayers for additional security, rescheduled proceedings, and extended court time now exceeds $12 million. This isn't about politics, it's about math. Robert Chen, veteran court clerk at the Southern District of New York, provided insight that reveals the human cost of this systematic erosion. He told reporters, "I've worked in federal courts for 18 years. I've seen emotional testimony, heated cross-examinations, and passionate advocacy, but I've never seen the deliberate destruction of the judicial process itself. When court personnel start their shifts wondering if they'll be able to do their jobs, something fundamental has been broken. Let that sink in. The broader pattern becomes undeniable when you examine the timing and coordination. Yesterday's incident was the fourth major courtroom disruption this month involving similar legal teams using identical strategies. The disruptions are not random, they are not spontaneous. They follow a precise playbook designed to render federal courts unable to fulfill their constitutional mandate. Constitutional scholar Professor David Kim explained the accountability gap that makes this strategy possible. Federal judges have broad authority to maintain courtroom order, but they face a fundamental dilemma. If they respond too aggressively to disruption, they risk accusations of judicial bias. If they respond too leniently, they enable the destruction of legal proceedings. This creates a window of vulnerability that sophisticated legal teams are now systematically exploiting. Here's the accountability question that nobody in power wants to answer. Who benefits when the federal court system becomes unable to hear testimony and render verdicts? The answer reveals motivations that have nothing to do with legal defense and everything to do with preventing accountability itself. When courtroom chaos becomes profitable for elite legal firms, when systematic disruption protects wealthy defendants from facing consequences, and when federal judges become powerless to maintain the basic order necessary for justice, we are witnessing the deliberate dismantling of equal justice under law. And this is where it becomes undeniable that what happened yesterday was not an accident, not a breakdown, but a successful execution of a strategy that threatens the foundational principle of American democracy itself. Here's what nobody is saying out loud. This courtroom incident is not an isolated breakdown. It is the visible symptom of a systematic assault on judicial authority that has been building for months across the entire federal court system. The data reveals the scope of what we're facing. In the past 12 months, federal courts have documented a 240% increase in motions filed solely to delay proceedings, a 180% increase in procedural challenges designed to halt testimony, and a 320% increase in what court administrators call systematic disruption events. These numbers represent the weaponization of legal process against legal process itself. Dr. Patricia Williams, former chief judge of the Second Circuit and current director of the Judicial Integrity Institute, provided the warning that legal experts have been afraid to say publicly, what we are witnessing represents the most serious threat to judicial independence since the court-packing crisis of 1937. The difference is that this attack is coming from within the legal system itself, using procedural warfare to render courts unable to function. Translation: our own legal procedures are being turned against us to destroy the courts from the inside. The pattern becomes undeniable when you map the timeline. 6 months ago, courtroom disruption was rare, expensive, and largely ineffective. Today, it has become a standardized strategy employed by elite legal firms across multiple federal districts. The evolution reveals a coordinated campaign to establish precedent that makes judicial proceedings impossible to conduct. Maria Santos represents what happens to ordinary Americans when the court system stops working. A small business owner from Queens, she has been waiting 14 months for her federal civil case to proceed to trial. Her case has been delayed 7 times due to what her attorney calls systematic procedural interference by opposing counsel. She told me, "I saved everything I had to pursue justice through the legal system. Now I'm watching that system be destroyed by people who can afford to break it. If courts can't function, what hope do any of us have for accountability?" Let that sink in. The Administrative Office of the Courts released internal data showing the financial impact of systematic disruption. The average federal case now requires 67% more court time than in 2020. Taxpayer costs for additional security, extended proceedings, and administrative overhead have increased by $89 million annually. These are not abstract numbers. This is the price Americans pay when legal proceedings become warfare instead of justice. Constitutional scholar Professor Mark Thompson explained the institutional damage in terms that should alarm every citizen. When federal courts become unable to maintain basic order necessary for legal proceedings, we lose more than individual cases. We lose the institutional foundation that makes constitutional democracy possible. Courts that cannot hear testimony cannot render verdicts. Courts that cannot render verdicts cannot provide justice. Without justice, there is no rule of law. And here's where the systemic nature becomes undeniable. The Federal Judicial Conference, which governs court administration, has called 3 emergency sessions in the past 2 months to address what they term the judicial functionality crisis. Chief judges from 12 federal districts have reported similar patterns of systematic disruption that make normal court operations impossible. The warning signs are everywhere. Court reporters are requesting transfers to avoid proceedings they describe as legal chaos. Federal marshals are documenting unprecedented challenges to judicial authority. Administrative staff report that basic court functions now require security protocols previously reserved for high-threat cases. Jennifer Martinez, a federal court administrator with 22 years of experience, provided testimony that reveals the human cost of institutional breakdown. Court personnel now arrive at work uncertain whether they will be able to perform their constitutional duties. When the people responsible for maintaining judicial proceedings lose faith in the system they serve, that system has already failed. Think about that for a moment. The temporal markers reveal acceleration toward complete dysfunction. January 2024, isolated incidents of courtroom disruption. June 2024, pattern recognition among court administrators. December 2024, systematic implementation across multiple districts. Today, federal judges publicly acknowledging their inability to maintain basic courtroom order. This isn't about individual cases anymore. This is about whether the federal judiciary can continue to exist as a functional branch of government. When elite legal teams can successfully prevent federal courts from hearing testimony, they have achieved something more dangerous than winning cases. They have demonstrated that the rule of law itself can be purchased by those with sufficient resources to destroy it. And the acceleration continues. Yesterday's courtroom chaos was not the climax of this crisis. It was proof of concept for a strategy that is about to spread nationwide. Now watch the domino effect. Legal experts are projecting consequences that will reshape American justice for decades. Dr. Rachel Kim, director of the Constitutional Crisis Project at Stanford Law School, warned, when federal courts lose the ability to conduct basic proceedings, 3 things happen immediately. First, civil litigation becomes meaningless because verdicts cannot be reached. Second, criminal prosecutions collapse because testimony cannot be heard. Third, constitutional challenges to government action become impossible because courts cannot function to hear them. Translation, we lose access to justice entirely. But here's what provides some hope. Federal judges in the Western District of Washington, led by Chief Judge Ricardo Martinez, have maintained strict courtroom protocols despite facing similar disruption attempts. Judge Martinez told legal reporters, "The rule of law depends on judicial authority to maintain order necessary for legal proceedings. We will not allow procedural warfare to render our courts dysfunctional. Every disruption attempt has been met with immediate consequences. That shows the system can still work when judges refuse to let it be broken." Thomas Rodriguez exemplifies the human resilience that keeps institutions alive. A career federal prosecutor with 26 years of experience, he has adapted his courtroom strategy to anticipate and counter systematic disruption. He told me, "I took an oath to uphold justice, not to surrender to legal chaos. When elite legal teams try to prevent testimony, we document every attempt and present it as evidence of obstruction. The law provides remedies for those willing to use them." Think about that. Individual prosecutors are fighting to preserve judicial functionality. The accountability question has now escalated beyond individual cases to institutional survival. What happens when the American people lose faith in the ability of federal courts to provide justice? The answer comes from constitutional history. When courts cannot function, citizens lose their primary peaceful mechanism for resolving disputes and enforcing rights. That creates conditions for either authoritarian control or social breakdown. The scale becomes clear when compared to other constitutional crises. The Watergate investigation succeeded because federal courts could hear testimony and render judgments. The civil rights movement achieved legal victories because courts could function to enforce constitutional protections. When courts become unable to operate due to systematic disruption, those historical precedents for peaceful resolution of constitutional conflicts disappear. Future implications extend far beyond current cases. Legal scholars predict a cascade of delayed justice that will create a backlog requiring decades to resolve. Pending criminal prosecutions will face indefinite delay. Civil rights enforcement will become impossible. Corporate accountability will disappear as companies discover they can simply disrupt proceedings until prosecutors give up. Professor Linda Chang, constitutional historian at Duke University, provided the historical context that reveals the stakes. American democracy has survived civil war, economic collapse, and foreign attacks because our institutional frameworks remained functional. When those institutions lose the ability to perform their constitutional roles, we enter uncharted territory where democratic norms cannot be maintained through legal process. Here's what citizens can do right now to protect judicial accountability. Contact your representatives and demand emergency legislation establishing clear criminal penalties for systematic courtroom disruption. Support organizations monitoring judicial integrity. Attend public court proceedings to witness institutional breakdown firsthand. Most importantly, vote for candidates committed to protecting judicial independence from procedural warfare. The window for institutional repair is narrowing rapidly. Federal courts that cannot hear testimony cannot provide justice. Citizens who cannot access functional courts cannot resolve disputes peacefully. Democracy that cannot maintain basic institutional operations cannot survive external challenges or internal corruption. And here's the timeline we're facing. Without immediate intervention, legal experts predict complete judicial dysfunction within 18 months. Cases will be indefinitely delayed, legal precedent will become meaningless, constitutional enforcement will collapse. The rule of law that has protected American democracy for over 2 centuries will be replaced by whoever has sufficient resources to purchase procedural chaos. This is not theoretical, this is happening right now, one disrupted courtroom at a time. Let me tell you about Judge Sarah Chen. Appointed to the federal bench 8 years ago, she has maintained courtroom order through every challenge until yesterday. After witnessing the systematic disruption that forced testimony to halt, she made a decision that represents hope for institutional recovery. She issued a judicial order establishing new protocols for courtroom conduct that carry immediate criminal penalties for procedural interference. Her statement was direct. The rule of law cannot survive when legal proceedings become impossible to conduct. This court will use every available remedy to protect the constitutional right to functional justice. That is what institutional courage looks like.